Good afternoon. It's Monday the 17th, and I promised BJ and Max that I would do a live stream soon, and I'm trying to do it today because it was a special moment today. We had a case ongoing in Ottawa. I'm going to be very careful not to disclose any of the details so that anybody's identified. And I have to say it was a really pleasant experience in Ottawa. Extremely fair and experienced trial judge, excellent Crown attorney, everybody interested in trying to find out, what was legitimately the truth. So I felt that the process was extremely good, and it was overall a good experience. What was interesting this was a case that the client was originally convicted, and somebody did an appeal. They did a very good job on appeal, and it was ordered back for retrial. But what was interesting was one of our podcasts talks about putting sex back in a box. And the reason we did that was when we were assessing the evidence for running the trial now, we realized that there was an excessive amount of bad character evidence given by disclosure witnesses and the complainant that we felt was completely irrelevant. And at the time, it may have been a fruitful avenue for then the defense counsel, but we thought it wasn't effective. And everybody has a different approach to it. So I'm not being critical because sometimes it can actually go to your benefit. But we felt it was very important to sort of focus. So we brought our application under 276, 278 to restrict all of the discussions about sexual activity really to the actual offense itself, save and except for a couple of other issues, including messages. We then reviewed the Crown-led evidence in the actual application, and then brought simultaneously an application to restrict bad character evidence. And that's why we did that episode on putting sex back in a box, because we thought it was very interesting to focus in a case like this only on what we thought would be directly relevant, that would not open up the doors to any type of irrelevant bad character or other evidence that would not assist in trying to find the truth in this case, which was ultimately that our client was not guilty of this offense. So I'm not saying that the judge gave a resounding decision to say he believes our client, but there was significant reliability difficulties with the complainant's evidence, and the Crown was arguing something that causes us concern, which is this trauma-informed analysis with respect to why a complainant may have difficulties with recounting events prior to or after the alleged sexual assault, incidents prior to that, and then details of the actual event itself. So yes, I believe that there is legitimacy to trauma-informed analysis, but you got to be very careful with that. But the judge did a very good balancing and found that there were so many reliability issues with respect to the complainant's evidence, with crucial evidence about attending my client's apartment, the time, why she was going there, what happened just prior to going into his bedroom. Very significant details, including aspects of the actual event in question, that there was just not enough cogency to her evidence that he felt safe to rely on her evidence to make any type of findings. And of course, we were restricted by what the client had said in the previous trial, and restricted by that prior pretrial motion. But when you start to strategize about it and think about it in a more sort of careful way about putting things back into a box and restricting evidence, we found it was extremely helpful in this case. And we're doing it in another case coming up next spring, where we think there is value to ensuring that you take steps to restrict the evidence so that you're focused on certain aspects and you get in what you need, but you're very strategic. And I might sound a bit obscure right now, but I'm just trying to say focusing and trying to restrict some of the Crown-led evidence is really important, because this was clearly a case where the Crown wanted to lead a fair amount of bad character evidence, which we think would have distracted from what would be the truth of the situation, and ultimately in our case proved to our client's benefit, because it was noise and he was really innocent of this offense. And I think the judgment was very fair in those circumstances. So we're going to do probably a podcast to drop soon about, putting sex in a box part 2, just explain in a little bit more detail about why we think it's important, what's the strategy behind it, what evidence to avoid, what Crown-led evidence we want to assess, and how we want to try and restrict it, which I think is important going forward for many cases, especially given the era we live in. So this was my first time doing a live stream. I have no idea if this is interesting, but it was kind of fun. I'm in my office. It's Monday, and I'm looking forward soon to going on vacation with my lovely wife, Marcy, and I wish everybody well, and thank you for listening to this little live stream of mine. Thank you. Bye.